Hi everyone. So today we'll be starting a new concept altogether, that is the principles of natural justice. But before starting the topic, I'll narrate you a story. I think this story you will also read when you'll be reading jurisprudence in your coming semester. But this is a very inspiring story in the sense that this story gives you the lesson that everyone can have a different viewpoint and yet they all be correct. Okay, so supposedly there is one flute, okay, and there are three different children, supposedly Maria, Mary, and John. Okay, so Maria is the girl who has actually made that flute with all her hard labor, and she is very much excited because applying her all the skills she has produced a flute. Okay, now Mary, she is a very lonely child and she has nobody to play. She's very much poor, and she therefore says that flute, she wants the flute because there's nobody with her and she'll play with the flute. Okay, and then there is John, who says that I am the person who has the skill to play the flute, so I can play it better, and therefore I want the flute. So there are three claims to the flute. Okay, so one girl is saying Maria because she has put her all the labor, therefore the right on the flute belongs to her. Now there's another girl, Mary, who says that because she is also poor and she has nobody else, and therefore it belongs to her. It should be given to her. Then there is this boy, John, who claims the right on the flute because he says that he's the only one who wants, who knows how to play the flute. Now, there could be different, answers to this thing. Now, some of you may agree to the claim of Maria, some of you may agree to the claim of Mary, some of you may agree to the claim of John. And I believe that none of you are right in your, none of you are wrong in your approach, because see, even the many jurists, they have also given different reasonings for it. For example, the people who support the labor rights, definitely they'll go with the claim of Maria because she has put the entire effort. So those Marxists, the people who support the ideology of Marx, definitely they'll support the concept of the idea and the right of Maria. And the people who support the concept of utilitarianism generally means that maximum happiness for the maximum people. Okay, so even if it causes pain to some few people, but in larger perspective, if it gives happiness to the larger section of the society, then we should go with that claim, right? And the people who support, and therefore there would be other set of people who are liberals who will support Mary, who is all alone, and therefore she needs the support system, and because there's nobody to play with her, flute may be a remedy for her, right? So therefore there can be different conceptions of justice, but it is not, therefore we cannot say that one idea is wrong and the other one is correct. So these principles of natural justice, they have actually developed when we started giving importance to the ideas, thoughts, beliefs, the logical reasoning of a human being, a man. Because if you remember, during the Dark Ages, if you question the authorities, if you will question the state, if you will question the church, then you will be considered a traitor, right? It will be considered as if it is a sedition in the present context. You remember why Galileo was punished? Because he said that it is the Earth and the other planets who revolve around the sun. So Earth is not at the center, rather it's the sun which is at the center, and he was being punished for the same. So whenever people question the authority, they were being punished for it. But at the time of Renaissance, right? The Reformation era, wherein people started questioning, and therefore a lot of importance was being imputed to their individual personality. And therein, when this idea of individualization of justice developed, that we started giving attention to the idea of natural justice. Although when you will study about its historical growth, it basically says that the concept has developed from Greeks and Romans, because from there comes the word just natural, and which means the natural law. Now, natural law here does not mean the law of the nature, wherein a lion will kill a lamb, and a tiger would definitely kill an antelope. But when we say a natural justice, it is something which is a higher law of nature, or a natural law where the lion and the lamb, they will lie together, and the tiger frisk with the antelope. So that is the idea of natural justice, which we equate with this idea of fairness, reasonableness, equity, and equality, right? So natural justice is something we relate with our moral consciousness. We say that natural justice is something which comes from within, which tells you that what is right and what is wrong. So, in that sense, if we equate it with the doctrine of due process, which is there in USA, and with the idea of common law, and in India, we relate it to dharma, right? Because it is also said that this idea of natural justice is not something new in India. In India, it was always prevalent. So, when we read a number of dharma shastras and dharma smritis, could be that by Manu Smriti or Yagnavalkya Smriti, or even when we read Arthashastra of Chanakya, here in everywhere, in all the phases of the development of history, could be ancient history, the medieval history, we will find that there will always been the prevalence of this idea of natural justice. So it's not something which is very much new. Even in our mythologies, it's been emphasized that, when the Rama asked Sita to leave, he acted as a king who was taking care of his subjects. And he acted on the principles, on the natural principles of law. Well, there could be a different debate altogether whether his act was right or not, and definitely there could be different feminist jurisprudence with respect to it. But idea here is only that the concept of natural justice is something which is not new, right? It is always there, which was prevalent in the ancient India, because it was always said that a judge should decide a case without any consideration of personal gain or any kind of a personal bias, as being mentioned in the text, that Brihaspati has said this in his text, and he has also emphasized that his decision should be in accordance with the procedure that is established by the text. Similarly, Katyayan, he says that if the king wants to inflict upon the litigants an illegal or unrighteous decision, it is the duty of the judge to warn the king and prevent him. So the position of the judge has always been considered to be something very pious, or discharging very essential functions, and therefore it has been considered that he should always act in very impartial and independent manner. Okay, then this independence and impartiality of judiciary is to be maintained all the time by the king. So, if you have read the text, the ancient text, and if you have read the ancient history, you must be aware of this fact, that there were always standards as to what will be the evidence, what kind of evidence will be admissible, how many witnesses are required for it, what shall be the nature of the witnesses. So all these things were already mentioned in our Dharma Shastras. So there was no doubt or confusion with respect to the principles of natural justice. But with the advancement of time, we recognize this idea, as I said, with the individualization process that happened during the Enlightenment era, during the Renaissance time. So there we started developing some systematic way. We started developing the idea into a systematic manner, and therefore we related this idea to the conduct of man and developed the principles of natural justice, that there should always be a reasoned decision, that the person against whom an inquiry is being initiated, he should not be a judge in his own cause, that other party should be given a fair chance of hearing. So therefore, one of you questioned me that when there is a violation of a legal principle, and there is that the natural principles of natural justice are being followed, can we challenge it in a court of law? So I said that, see, the principles of natural justice are not in contravention to the principles of law. Principles of natural justice will rather come to an aid when the principles of law fails to deliver the justice. So they are complementary, and there can't be any clear-cut line or a demarcation between the idea of legal justice and natural justice. Okay. But definitely, when there is a concept, definitely there are criticism to it. So the very obvious criticism to the idea of natural justice is the principles is that it is a very vague concept. You cannot define it very clearly, and for different people it means different things. So for a lawyer it is something else, for writers it is something else, for judges it is something else, for common people it is something else. Sometimes you relate it to your morality, to consciousness, to logics, to rationality, and these are something which is very much subjective, right? So therefore you cannot always determine as to what is justice for one party and what is justice for the other party. As I gave you the story, I gave you an example of it, just to let you know that idea of justice, vary for different people. Although we say that it is only one divine truth, but definitely there can be different ways to attain that truth, right? I know I'm being more philosophical, but that's the truth. कि जब कहा जाता है कि भगवान तो एक ही है, उस तक पहुंचने के रास्ते अलग अलग हो सकते हैं. In a similar way, when we read the concept of natural justice, the same applies here. Although it is something which is very vague, accepted, but it does not mean that it does not exist, right? It comes to the rescue of people when there is complete denial of justice to them. Now, therefore, to all these criticisms, there is a very beautiful answer given by Lord Reed in the historical decision of Ridge versus Baldwin that we'll be reading. It is a very interesting case. So, Lord Reed has said that in modern times, opinions have sometimes been expressed to the effect that natural justice is so vague as to be practically meaningless. But I would regard these as tainted by the perennial fallacy that because something cannot be cut and dried or nicely weighed or measured, therefore it does not exist. तो कहने का मतलब है कि अगर आप किसी चीज को उसको स्ट्रिक्ट वे में, अगर उसे एक स्ट्रक्चरल फॉर्म में, यस और नो के आंसर्स में अगर आप नहीं देख रहे हो, तो इसका मतलब ये नहीं है कि वो एग्जिस्ट नहीं करती और वो हेल्पफुल नहीं है, right? So principles of natural justice, through various decisions of the courts, it could be easily ascertained, and through their application in a given situation, they may depend on multifarious factors. So for fairness itself, it is a flexible, pragmatic and relative concept, not a rigid, ritualistic or sophisticated abstraction. It is not a bull in a china shop or a bee in one's bonnet. Often the concept of natural justice is criticized as being unruly horse. So even Lord Denning has replied to it, and he said that with a good man in the saddle, the unruly horse can be kept under control. Definitely. जैसे B.R. Ambedkar ने कहा था, I can relate to it, that it is not that a constitution is good or bad. It is the people who will use that constitution for their generation that will decide that how that constitution works, right? So Lord Danning is saying similar thing, that with a good man in the saddle, the unruly horse can be kept under control. So it can jump over obstacles. It can leap fences put up by fixtures and come down on the other side of the justice. So therefore, natural justice is something which comes to the rescue of man all the times when he is in need. And natural justice contains yields to change with exigencies of different situations, and therefore do not apply in the same manner to situations which are not alike. तो हर जगह ये जरूरी नहीं है कि आप यूनिफॉर्मिटी पे ध्यान दें, कि हर जगह वही प्रिंसिपल्स अप्लाई हो. अंडरस्टैंड दैट रूल ऑफ लॉ डिमांड्स दैट देयर शुड बी प्रिडिक्टेबिलिटी, but that does not mean always that uniformity should be there so as to cause injustice, because the basic idea or the basic aim of the system is to deliver justice, to deliver substantive justice, and therefore it is necessary that some kind of flexibility should be there in the system. So therefore, this idea of natural justice is something which is a very pervasive force, is a pervasive facet of a secular law, where a spiritual touch, with a spiritual touch, it enlivens the legislation, administration, and adjudication to make the fairness a creed of life, right? So when I'm saying that it is having a secular touch, by now you would have understand it. But even it is being said that when even Adams, they were being punished by the god, so they were given a chance to put their own side of justification as to what is their side of story. So they were given a chance. Similarly, if you see the concept which is being developed by Ashoka also, that he focused a lot on the behavioral aspect of the people, and therefore that is how I believe that how Ashoka and Chandragupta actually differed, because Chandragupta completely abide by the Arthashastra that was given by his master Chanakya, whereas Ashoka focused more on the nature of the people. So therefore, law need to be molded in that particular way and applied in different circumstances according to the situations, and that also becomes necessary. So from this, I would like to conclude that justice can be ensured through institutions. Definitely. That is the idea of John Rawls as well. And therefore he says that if you want that if you want that justice should be there, it is very necessary that the institutions in your country should be working well. And to ensure that the institutions in your country working well, what you should do is that you should consider that everyone in the society is on the same pedestal. He is completely unaware of his or her position. It means you will forget as to whether you are a male or a female, whether you are poor or rich, to what social strata you belong. You completely forget it, and you all come together and you make those laws which are beneficial for the entire society. And for those people who would be at a weaker position, who would be at the margin of the society, they should be given some specific benefits. So therefore, a pregnant lady would get some different benefit, a person who is having some disability would get a different benefit, a child would get a different benefit. So therefore, when you will be studying jurisprudence, you will get to know that this idea of reservation in the Indian Constitution is also derived from this concept of John Rawls. But there is a criticism that is being put forth by our Nobel laureate Amartya Sen, who says that yes, fine, we agree that institutions are definitely important, but it is also the behavioral aspect of the person which matters the most. Because if the institutions are abstract entities, right, who will comprise those institutions? The institutions are being comprised of the people, right? So howsoever you form these agencies like CBI or CID to take care that there is no corruption, you form these institutions, but definitely to ensure that they function in an impartial manner and they serve the purpose for which they are being created, it is necessary that the people should also be having that impartial character. So therefore the need of the time is that we should focus on the individual behavior of the people finally, right? So even today you see that there are being problems in the society of that the riots happened in Delhi recently, and there's always a communal clashes that goes on in India. So now it is the time to introspect as to whether institutions in themselves, whether the branches of government in themselves are sufficient to deal with the problem, or it is now the role of the society, a greater role of the society has to be played at this point of time to specifically direct the society in a positive direction, to change the mindset, the behavior of the people, to be to progress, to be a $5 trillion economy which we are aiming for. Okay, so why I'm telling you all this is because we cannot read administrative law in isolation. Administrative law has its connections with different things, because it has connections with the idea of equality, it has its connection with social justice, it has its connection with the economic development, it has definitely connections with the environmental jurisprudence, it has connections with the feminist jurisprudence. So number of things are being involved into it, and as I said that when we were reading tribunals and codes, that these administrative agencies are being more influenced by the policy considerations, and therefore it becomes important to take care that the people who are the policy makers, right, there should also be a change of mind and change of mindset there. So the entire idea of principle of natural justice is based on this idea that we achieve a ideal state wherein everything functions in an impartial, independent manner. And if we talk of the natural justice in our Indian constitution, you will see it's embedded everywhere from the beginning of the preamble. From the beginning of the preamble till we go to Article 311, which is regarding the rights of the civil servants, you will see that the principles of natural justice find expression. Definitely the chapter of fundamental rights, when we specifically talk of 14 and 21, when we talk of directive principles of the state policy. So therefore the idea of natural justice is, you'll find the thread of this principle everywhere in the Constitution of India. So for us it is not something which is new. The only thing is that we have given it a particular structure. We have identified the concept through various decisions, and we have strengthened the concept. We have respected in myriad ways and myriad decisions. Okay, so therefore we'll be reading the concept of natural justice, but it's not only important from the perspective of an administrative lawyer, but it also becomes important from the perspective of a citizen. And if you really want to develop some juristical thinking in the development of law. Okay, but let's come back to the concept of administrative law. And therefore the question comes as to where do you apply the principles of natural justice in administrative law, then we can say that every administrative action that causes a prejudice or a harm or adverse consequences in the civil life, it inflicts civil consequences, then the principles of natural justice are attracted there. So, they are attracted whenever a person suffers a civil consequence or a prejudice is caused to him by any administrative action. Even the loss of legitimate expectation may attract the principles of natural justice. So therefore, when a person cannot justify his claim on the basis of any law, but he suffers a prejudice or adverse consequences, he is entitled to the benefit of principles of natural justice. Even if I will conclude the concept, the origin and its importance with the lines of Blackstone, who has written a commentary on the laws of England, and he has said that no human law are of any validity if contrary to this means the natural law, the natural justice, and that a court of law could disregard an act of parliament if it is contrary to the natural law. See how much high pedestal the rule of natural law is being placed in UK. And the concept of natural law and natural rights has also influenced the drafting of the US Constitution, and it is also the basis for many international conventions, covenants, and declarations. Now, do you remember that when we were studying the classification of administrative functions, we read the difference between an administrative action and a quasi-judicial action? So, and I told you therein that now the difference is diminishing in the sense that if there is any event and to which any civil consequences ensue, there is hardly any distinction, because the principles of natural justice are attracted in both the situations. So even the purely administrative authorities, the executive authorities, are also bound in certain way to the principles of natural justice. They have to abide by the fair play thing, that they should be very much fair and transparent in their action, because there is this development after the case of Ridge versus Baldwin. So if you see today and you go on to write the difference between administrative action and the judicial action, you need to write this, that now it has actually obliterated, that there's no such difference on this basis, that principles of natural justice would be followed only if it is a quasi-judicial action. No, it has to be in some manner followed by the administrative agencies as well. Therefore, the application of the principles of natural justice is something which is very, very wide. And we relate principles of natural justice, as I told you, to a number of things. We relate it with our conscience, we relate it with moral law, we relate it to the idea in today's time, to the idea of good governance as well. And nowadays, if you remember, specifically the idea of constitutional morality, which has come up after the Sabrimala judgment, we have started talking of constitutional morality. So all these ideas which have a spiritual connotation, which has a political connotation, social justice, economic justice, and political justice connotation, all this is related in some way or to the other to this idea of natural justice. Okay, so natural justice is something of very, very much, very importance for us. So we'll be reading the different components of principles of natural justice, right? Rule against bias, and reasoned orders, and audi alteram partem, that is the rule of fair hearing. Okay, so I would like to hear from you. If you have any queries or any suggestions, kindly respond, and please listen to the audio. That may be helpful for you. Okay, all the best. Thank you. Hi everyone.